So today we're going to be covering the sources of EC law, the European Communities law, or the European Union law. And you can find all the details in your reading pack, as usual, as always. And you can go into details, and I'm hoping that you read it before you come here. That's my honest to God hope. And let's go into details about how the sources of EU law is structured in a way. I like pyramids, as you all know. I'm going to make a pyramid kind of shape again. Not necessarily it's showing the quantity, by the way. This is not like there's no quantitative, in that sense, correlance with my pyramid today. And with the amount of the percentage that is required in the European Communities law. So on the very top of the pyramid, we will see the treaties. These are the treaties that have founded the European Union, or those are the treaties that have amended and changed the structure, institutional and political structure of the European Union. These are the founding treaties and amending treaties. What are those treaties? Which treaties I'm talking about? Some volunteers back there?
Lisbon Treaty?
Yes, Lisbon Treaty. We can start from the Lisbon Treaty as well and go backwards. But yeah, Lisbon Treaty is one of the treaties.
Treaty of Paris.
Sorry?
Treaty of Paris.
Treaty of Paris. Treaty of Rome. Nice, Amsterdam. Maastricht, or the Treaty of the European Union. You're missing one thing because it doesn't have a treaty in the name, but it's also a treaty. Single European Act, right? Those are all the treaties that are either founded. There's also a merger treaty, which make the communities merge together, the merger treaty as well. So all these treaties are the primary sources, as we call it. These are the primary sources, the treaties that have founded. I mean, I don't have to, I think, make the whole list. You more or less know all of them. The Rome, the Euratom Treaty, merger, so far. It doesn't mean that with Lisbon Treaty we're stopping. I mean, we might see another treaty that is coming according to the needs of the European Union, according to the political and economic and social and all sorts of needs, that we can have another treaty that's coming up in the future. But these are the treaties which are the primary sources, and these treaties are binding for all member states that they have to apply because it's the foundational source of the EC law. And later on, we also have secondary sources. And things become a bit more tricky here. So let's have a look. I think I might have to make my pyramid a bit bigger here. Primary sources. And at the second level, what we see as a secondary source is first of all, the regulations. So hierarchically speaking, talking about the regulations first. Regulations are the sources. These are the sources that are being created by the EU institutions. This is the secondary sources are the legislation that has been created by the European Union institutions. These institutions, as we covered previously in the previous weeks, the Council, the Parliament, and the Commission and other EU institutions as well, they automatically become law in member states, and they are generally applicable, binding in their entirety, and they're directly applicable. So what does that mean? They're first of all binding. You cannot pick and choose. And all member states have to apply these regulations. So it is covering all member states. It's addressing all member states. So all member states of the European Union have to be applying these regulations. And they're ball binding. You cannot pick and choose whether you would like to apply it or not. And they're directly applicable. What does directly applicable means? It means that the EU member state doesn't have to do anything particular in its own national law to make that regulation becomes part of its national law. So they are directly applicable. It's like the regular law that we see in a country. For example, if we accept a law, in the law there's going to be a deadline, or there's going to be not a deadline, but there's going to be an entry into force date for that law. And if that entry into force date, it states in every law, by this date, this is going to become, and this law is going to enter into force. And from that date onwards, that law will be in force in that country. It's the same kind of thing. As we do it in our national system, that we don't necessarily have to do something particular in terms of the legal action to make it part of the national law. It's the same kind of thing with the regulations. So it will also have a date that will make it, that will specify the entry into force. And after that date, that regulation will be entering into force directly. There is no need to have a national action that will take place. So it's very straightforward. Is it clear so far? Are you clear in terms of understanding? No? Confused? It becomes a bit more confusing afterwards. That's why I'm asking, are you clear by that? Because if you're not clear by now, it's going to be becoming a bit more complicated afterwards. No, that's why I say all member states. It covers all member states if there is a regulation. So when you hear about a regulation, then you have to think that that regulation is going to be binding for everyone. That's the highest kind of thing. It's the same thing at the national level when you think about it. At the national level, we have the constitution, we have laws, and then from laws onwards, I mean, obviously the name can make it confusing now when I compare it with the national versus the EU level. Because in the national level, we have law and regulations and directives, and it goes on like that as well. Anayasa, kanun, işte yönetmelik, tüzük, genelge vesaire diye gidiyor. Bağlayıcılıkları daha az oluyor. Yani hukuki sistem açısından hitap ettikleri kişiler ve kurumlar ve aktörler değişebiliyor vesaire. O yüzden farklı nitelikleri oluyor. Aynı şey burada da geçerli. And if you go a bit further, it's the problem of teaching like 3 hours before. By the time I come to your class, I already lost my voice, usually. Yeah.
So, are the criteria for every state same or different?
Same. They're same.
Like, I mean, you have to apply this regulation for 1 month?
Let's say like we accept some regulation right now today, and we say that from 1 month onwards, let's say the 1st of January 2015, this regulation will get into force. And on 1st January 2015, this regulation, let's say the quality of, I don't know, air standards, or in terms of air pollution, will get into force by that time. So that day onwards, that regulation will be operating. Before that, it wouldn't be operating. Or let me make you like simple for you. Let's say that I say that from 1st of January onwards, bringing water to the classroom is going to be banned. You cannot bring. And if you do bring water, then you're going to be fined 50 liras. But now I cannot fine you, right? Because it's going to be valid from 1st of January onwards. So if you brought the water bottle here already, it's fine. It's okay, because there is a date. And it's going to be covering all of you. I cannot make exceptions for Merve, for example, right? So Merve doesn't have an exception. Merve is bound by it. Everybody is going to be bound by this in this classroom. Let's say we're the EU. And I don't have to do anything specific, and you don't have to do anything specific. It's going to be covering all the member states. It's going to be binding. You can't say I opt out. Because of health reasons, I have to have a bottle of water each time with me. I'm sorry, that's not a valid argument. It's binding for everyone. So, Yeah.
What if because of some reasons I cannot meet this criteria?
So we're coming to that. There are different mechanisms. Because of those kind of needs and everything, we have different mechanisms, right? So that's the more, in that sense, strict kind of, it's a more strictly applicable instrument. That's why they have different instruments, because for different needs and necessities, this and that, they had to develop different mechanisms. So regulations. And if we move on from regulations, we have directives. Directives are also binding. But the difference is, in terms of its direct applicability, there is a difference. How you apply is left to the member state. So its applicability or its transposition at the national level is left to the member state. So each member state still going to have a deadline. Let's say 1st of January onwards, it's going to enter into force. So you will have that deadline, and until that time, you have to do your national legislative, preparations or etc. To make it valid from that deadline. It's usually regards to the issues that really relates to harmonization of national laws with the EU. What does that mean? Let me give you another example again. Let's say I said from 1st of January onwards, again in this classroom, I would like you to have computers with you. Everybody will have a laptop. Because I require something very specific here, and obviously all of you will need either, if you have a laptop, you will have to have time to bring that laptop, or you might just borrow it from a friend, or you might just have to buy a new one. So it will depend how you will react to that. I cannot tell you that everybody will have to bring their own laptop. It's up to you. I just need a laptop. So 1st of January onwards, I need a laptop in this classroom. So it will be up to you how you will be bringing that laptop. I'm not deciding on that. So it's up to you. So you're not using my methods in this way. In this way, you're using the EU methods, which means it's directly applicable. So it gives you a little bit more room in terms of adapting. It's usually done through, as I said, harmonization processes. So if you already have a policy that's going on, it gives you a time to adjust your national law and harmonize it with the EU legislation, because it's binding again. So the critical thing that it's binding. And obviously, usually the deadline is not 1 month. Usually the deadline is much more longer, so that gives you time to adjust your national legislation accordingly. But for the simplicity reasons, I'm just giving a 1 month example. And if we move on, we have decisions. Decisions are also binding. But they're addressed to either a member state, or a company, or an individual. And they're only binding if they're addressed to the member state or the individual and the company that they have been addressed to. So it's not binding all member states. So that's the difference. So it's more targeted in that sense. It's more specific, it's more targeted. It's usually the case that the decisions are usually addressed to more technical and detailed issues. So I can, for example, address it to Merve, saying that, Merve, you keep on bringing that water every day, let's say to my class. From now on, I would only accept bottled water, but not in a cup. So it's going to be only binding Merve because of Merve's specific needs. Because let's say that Merve needs every day she has to have water because she has sugar level, blood sugar level problems, this and that. I'm just making up a story right now. So it can be specific to her, and it can be a very technical issue that can be addressed to her. But when there is a decision, it's also binding for Magda. Magda cannot say, I'm just opting out, because it's specifically addressed to her. Or it can be specifically addressed to an individual, or it can be specifically addressed to a company as well. So that's the difference. And if we move on in the secondary sources, these are the binding ones. But there are some unbinding ones too, so they're not binding. Those are recommendations. Let's put it down here. They're not binding. So if they're not binding, what do? These recommendations or those opinions, they have no legal force, so they're not binding. But they are persuasive. What does that mean? For example, the European Parliament can have a recommendation to the member states about a particular issue. For example, air pollution. It will be just a recommendation that the member states should take action in terms of air pollution by 2020, let's say. And it's not binding, but it's kind of a persuasive message that is given to the parties that have been addressing, and giving this message that it should be a priority issue. As European Parliament, as the citizens of the European Union, we think that those topics have to be taken into consideration. The same thing with the opinions as well. So they're not really trying to be enforcing a certain message, but they're kind of bringing certain issues into the agenda. They're raising certain issues, and what they do is that they're trying to be persuasive. And they usually, for the future, they can turn into, over time, they can turn into more binding legislation. So that's the difference. And we also have soft law, as we call it. These are the guidelines. These are the guidelines, how things are done, basically. There is a certain style of doing things in the EU. And there are certain guidelines how things are operated within the EU. So these guidelines or notices, they also have no legal force, but it has a good way of influencing the policy. How can I give an example? In METU, for example, there is no such a regulation that says that people in ODTÜ will be referring each other hoca, right? It's not written anywhere. And there's no binding mechanism that is enforcing this, but most of the people would be calling each other hoca. You don't have to be a hoca to be called hoca. That's the general attitude. So it's not written anywhere. It's a basic kind of guideline in that sense. And usually it's, it's very understanding kind of way of doing things, like in terms of respect to each other, this and that. I mean, these are not written things. These are not like enforced. So if you don't call somebody a hoca, it doesn't mean that. I mean, the university is going to take an action towards you. But it's how things are done. It's how to be not to, for example. So these are the guideline kind of things. And in the EU, there's also certain guidelines how commission is operated, or how certain notices as well. So these are accepted rules. It's not legally binding, so it's not binding, but it just gives you guidelines. So that's also not binding. So all of those, up until the soft law, are called secondary sources of the EU law. If we move a bit further, what we're going to see is the tertiary sources. Tertiary sources are the ECJ divided case law, for example. So let's make the the vision more clear like this. How the ECJ decided on the cases. And it's quite vital, we discussed it, why the case law is very important in the European Union, because the power to ensure the observance of the treaty objectives are done through the case law. And it also adds to the judicial creativity of the European Court of Justice. We discussed about the judicial activism of the court and how the European Court of Justice judges in terms of use the case law and the EU to push further for the integration, even in the cases of more intergovernmental periods. So they were able to use the cases and they used their power in terms of in their interpretation of the EU law to push the integration a bit further. So they decided mostly for the EU interests rather than the member state or individual interests. They tried to push for the EU interests. So that's how it's been presented. So that's why the ECJ case law is also an important source. So what are the other sources then? We also have the international treaties that has been signed. That is also going to be a part of the EU law. And these are negotiated by the European Union. Also, the acts adopted by the representatives of the member states at the Council. Acts adopted by the member states at the Council meetings. The national legislations, obviously, in the member states that are going to be also part of the territorial sources. And there's one additional issue that is part, and these are the general principles. Plus, and I'm going to talk into detail, so I'm not going to that, general principles. These general principles are basically the general principles in most of the member states as well. In any kind of democratic legal system that you will have those general principles. One of them we discussed, for example, last week, equality principle. They should be equal in front of the law. And also proportionality, legal certainty, natural justice, and protection of the fundamental rights, and the subsidiarity principle. And I'm going to be going into more detail about these, so I'm not covering them right now. So that's if we're going to have a pyramid structure. The pyramid structure just reflects the hierarchy more than anything, not the quantitative amount. It kind of reflects to the quantitative amount as well, because treaties almost represent 1% of the entire EU law. So it's only a very, very small percentage, although they're more binding, they're more, in that sense, powerful compared to other sources in that respect. But it's only the 1%. Most of it is the secondary sources, basically. Nearly like 90% that the EU law we're talking about are actually the legislation that has been produced by the EU institutions. So the legislation that's been produced by the Commission, by the Council, by the Parliament, that's what we're talking about. So that's the main body of the regulations. I have certain percentages, but I mean, they're not very accurate. But just to give you an idea, maybe, what we're talking about is about 30% will be the regulations, 9% directives, and about 40% it's going to be decisions, and 13% is going to be the recommendations and the opinions. So as you can see, 90% we're talking about the secondary sources in total. And the territorial sources with international conventions, international agreements, international treaties, and it will be about 9%. So that's just to give you the main body of the EU legislation will be about the secondary sources. That's the most critical part we're talking about. So, and we also have, maybe I should also mention, nowadays, because of the treaty structure has adopted these new tools, we also have joint actions and common positions as well, somewhere in between here. These joint actions and common positions, they are they're dealing with the joint actions. The scopes and the means of action is defined, but in the common position only defines the approach. These are most of the issues that are dealing with the common foreign and security policy, the foreign security policy of the EU that has been involved, and why the EU had to develop different kind of mechanisms. Why it doesn't have only, let's say, a regulation or a directive. Any ideas? Why it had to come up with this more creative approach of having different mechanisms instead of one? A treaty and a regulation, let's say. Why it had to come up with regulation, directive, decision, joint action, common position, recommendation, opinion, blah, blah, blah. It's more complicated in a way. Why it needs more diversity?
Because it's diverse itself, like you have 28 countries in one union, which means that they have like a little bit more specific capacities in terms of like their beliefs.
Yes, that's one approach, because they're not even themselves are diverse. We're talking about different member states, different interests, different legal systems, different mechanisms, different political systems, administrative systems. That makes everything more complicated. But within even the nation state, which is less diverse in that sense, still we have this kind of diversity. Why is it like that? What's the logic behind it? The logic behind this is, no answer is coming. I'm moving on. The logic behind it, because you need it for different purposes. You have different purposes, different objectives, and in order to achieve those objectives and purposes, you have to have different mechanisms. Sometimes you only need to address one country or one nation. Why should you come up with a policy that is going to be so specific at one level that is going to be binding for everybody else? Then everybody else has to harmonize this legislation, this and that. Let's say if something that only relates to a certain type of fish in a certain type of river that is, producing that fish, or that is specific to that area. So you don't necessarily have to have an EU-wide legislation that is binding for every member state, because it's so specific. It's only dealing with a certain area or a certain action or a certain policy framework. So you don't necessarily have to generalize that issue then. You have to be very, very specific in that regard. But that's one of the main reasons why it has to be diverse. And sometimes if you want to give a very clear message, and if you want to have, in that sense, a more powerful action about a certain topic, then you have to have something more binding, and it's going to be binding for all member states. So depending on your objective, depending on your goal, what you want to achieve, how you're going to achieve it, then you will use different mechanisms. Also going back to, not Alimat, what was your name? We're on record, right? So going back to that issue, that also is an important matter. Why? Because some member states may be willing to not to give a certain kind of message, or they want to be opting out. So they don't want to be having a certain policy area pushed in a more, at a more stronger and binding type of mechanism. So there can be also different interests. There will be different agendas that has to be presented as well. So that can also make this diversification too. Because we are not talking about a homogeneous group of member states. We're not talking about, even including the institutions as well. Different institutions might push for a certain different type of mechanism too. So that's why we need to have different mechanisms to be able to tackle different issues and different challenges. If we go back to the principles issue, as we discussed the principles as well, before we go back, I'll go back to the directives, because I think that's one of the places where you might be getting confused. What do you mean left to the member states? According to the directives are defined as such. A directive shall be binding, according to Article 249. A directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods. So there are two key aspects in that regard. One of them, it's binding as to the object to be achieved. So it is trying to achieve a certain aspect. That's the aim of the directive. So a certain objective is aimed to be achieved. So it's not trying to move the scope from that, away from that objective. It's very specific. It's trying to achieve that objective. It's one thing. And it also shall leave to the national authorities the choice of form and methods. So how it's going to become part of the national legislation, it's up to the member states. It's directly applicable and they demand absolute uniformity, but they didn't use it that way because they wanted to make sure that the member states adopt their own laws for the application of the common standards. So they're about harmonization of member states' law on specific issues. So this gives a bit more room for maneuver for the member state, basically. Because if they did it, let's say, like a regulation, binding all member states, and it's directly applicable, some member state might have objected it. So that's why sometimes it's more in that sense effective and efficient to move and make it as a directive, that legislation, and leave it up to the member states, the mechanisms to adopt it. So there will be more member states who will be willing to accept that kind of directive, for example. It's all about politics as well at the same time. We're talking about different legal mechanisms, but we're talking about politics at the same time. So to make it possible for the member state to accept it and apply it. So it gives the time and the mechanism and the method to the member state to apply it. But sometimes adapting to certain legislation or harmonization can be costly. It can be costly in terms of economy, in terms of politics. So because of those reasons, you have to be very careful when you're deciding on certain things. So in the guest lecture, I hope that you will be able to see that how harmonization in a certain type of industry can bring different kinds of costs to that particular industry. Because in order to come up with a certain standards, the EU standards, you have to adapt your legislation, your standards, how you operate things to a certain level. And that can incur certain institutional or administrative or financial costs. So leaving it up to the methods, to the member states, will at least ease the pain for the member state. And they will be more willing to do it in that respect. So let's move on into the principles. The general principles of law are the general principles of law everywhere in the world. The first principle is proportionality. Proportionality. What you're doing with law is that it has to be proportionate. The action versus the reaction has to be proportionate. It's usually the case everywhere in the world. So what I'm trying to mean is that, let's say you stole a piece of chalk from a stationery, you should not be put into to prison for a lifetime. That's not proportionate. So because if you put the person who's stealing the chalk in the prison for a lifetime, what are you going to do if a person kills somebody else? Or, I don't know, kills 5 people? So what kind of reaction that you're going to give as a punishment. So it has to be proportionate. That's one of the general principles of law. So especially it was the case with the International Handelsgesellschaft case as well. The ECJ adopted this principle, and it's named it as following. No burdens should be placed on the citizens except to the extent that it is necessary to achieve the purpose. So beyond achieving that purpose, there should not be more burdens that is left to the citizens that are being affected by that act. So you should be trying to achieve the purposes, but you should not be trying to achieve the purposes that is beyond what has been intended at the treaty purposes. So it's kind of, in that sense, also limiting the scope as well with this principle. So you're putting certain boundaries in that respect. So if the action imposes too great a burden for an actual breach of the EC law, an obvious context for this is for example, the fines that are imposed for the breaches of certain articles in the treaty structure, for example. So you have to make sure that what are you trying to achieve, what kind of actions you're taking to achieve those goals. If you're trying to move beyond those purposes, let's say it's trying to achieve a common market, but you're not trying to achieve one single economy that is all the way integrated. So there are certain limits what purposes you're trying to achieve. So what you're trying to do should be proportionate to what kind of actions you're taking. I think it's a very valid principle that we sometimes forget, the proportionality, what you're doing and what you're achieving, basically. It's a general principle of law. If we move on, we discussed this a bit more in detail last week, the equality principle. That's also a basic principle that we take it for granted usually. It says that there shall be no discriminations based on different issues that I will be discussing. So equality in front of law, basically. Equality, Article 12 prohibits any discrimination based on nationality. So just because you're from one member state should not be creating any kind of discrimination. Also, man and woman, Article 1401, demands the man and woman shall receive equal pay for equal work. So man and woman should be receiving, it makes like sense for you, right? Yeah, of course. Men and women should be receiving equal pay for equal work. But in practice, most of the cases we see that that's not the case. Because man is perceived as the main breadwinner of the family, so they usually get paid more. And there are different statistics in different member states, and surprisingly, in certain member states that you wouldn't even expect that there's going to be a huge difference, there are huge differences. You would be doing the same job, let's say you work in a bank, two people sitting next to each other doing the same kind of job, but the woman will be paid, in some cases, like 25% less than the man. So there will be a discrimination in terms of the payment as well. And you might think, wow, that's crazy, why should it be? But it actually happens. So that's why the treaty obligations tries to make sure that there is going to be equal pay for equal work. A basic principle, sometimes not observed. It also prohibits discrimination between producers and consumers in relation to the common agricultural policy. With the Treaty of Amsterdam, this equality principle has been extended, and it's been extended into different. And for example, now a commission is more active in tackling discrimination and promoting equality at different levels. So it's been extended, including like specific provisions for tackling sexual harassment, for example. So when you think about it, you just take it for granted, but this has to be over time developed through the treaty structures and included in the treaty structures as well. Also proactive, the ECJ is also being proactive with certain specific cases that it has decided so far, combating discrimination and advancing equality. So in that case, it's trying to be pushing a bit further in terms of creating this equality principle valid at least at the level of the EU, that is going to be applicable in other member states as well. And there's another issue, another principle, Legal certainty. And what does legal certainty means? It means that we also take it as granted. The law, it has to be, in terms of its application, has to be both certain and predictable. So you should know what the law is and how it's applied. There shouldn't be a question mark how it's applied, and there should not be differences in terms of its application. So it's applied in a different way in one way, and another time another different way, and another time another different way. So you have to be making sure. And in terms of that, it also gets into the issue of the entry into force issue. It's the same rule applies at national law as well. There is an entry into force date. And after that date, that law is going to be valid. And you cannot punish somebody for certain actions that has done previously. So it cannot be retroactive. You cannot go back and like punish a company or individual or a member state because they acted in a different way. Because the law has only become valid after entry into force date. This is a general principle of law. It's in Turkey too. Let's say that they change the law right now, let's say. Let's give an example again from here. The pass grade is about 60%, as you know. If you get 55% from any class, you're going to fail. And let's say that they change this rule, which is going to be valid from, let's say, 1st of January, not 1st of January, 1st of March onwards. And it's going to be 70% from now on, from February onwards. Nobody can go back in April and say, well, you passed this e-law course with 60%, well, too bad. Now it's 70%, you failed, and you have to take this course again. It cannot be retroactive, because by the time that you're taking this course, a certain kind of regulation has been in place, and you are bound by that regulation. So you cannot go back and retroactively act. So that's another principle. And natural justice. Natural justice is another concept that is actually valid to every, in that sense, familiar to most people. So the right to have a fair and unbiased hearing, right? You should be heard fair and unbiased in front of a court. And you also have to have a right to be heard before making a potentially adverse decision. So you should be, if there's going to be a decision that's going to be adversely affecting you, you should be heard first. So that's how it works as well. Again, giving an example, let's say you're sitting for an exam and the exam invigilator says that you've been cheating and it has a report. You will be called and you should be able to give your defense. Like, no, I was not cheating, blah, blah, blah. I was just like checking my phone or blah, blah, blah. And then the invigilator thought that I was cheating. So you should be heard first as well. So nobody can in that sense, have a decision that's invoked against you. And you should also have a right to have a reasoned decision. And then somebody can argue that this can be a very subjective issue as well. But ECJ has addressed the right to a hearing at quite an early stage onwards, from 1963 onwards, and they gradually developed those principles as well. And the fundamental human rights, protection of fundamental human rights. As we discussed last week as well, in the beginning at the Rome Treaty, it didn't have a list of the rights, political and social rights. Most it was referring to economic rights, right to property, basically, right to be able to make trade, those specific rights, mostly covering issues that relates to economy and a common market. But over time, it was necessary, it was inevitable, and that's how we see the spillover effect, that in order to establish a common market and have a actually effective and uniform application of the EU law, that you should have, you should protect the fundamental rights. And last week we see how gradually the ECJ pursued this area, and this vagueness, and in that sense the gap, has been filled with the case law of the ECJ, and the ECJ developed those fundamental rights principles, and how we came at the end to the level that we have now a Charter of Fundamental Rights that are included in the treaty structure, that now we have at least a list, basically. And the fundamental rights protection is also a general principle of law in almost all democratic systems in the world, that you should be protecting the fundamental rights. There is one issue that is more specific to the EU, is the subsidiarity principle. This is a principle that's been developed particularly for the EU for various reasons, specifically for the reason in terms of defining the EU competences. It's a long process of bargaining, basically, intergovernmental bargaining, who should be involved where, how much power the EU has, what kind of competences the EU has, what kind of competences basically the member states should have, or at the local level. Any ideas how this principle has been developed, and what is it about? Anybody who's working on the Eurosima who heard about this before? No? I'm surprised. There are usually like one or two people who at least heard about this. So the subsidiarity principle is basically that it tries to create a delicate balance between who's going to be involved in terms of competences. At one level, there are lots of member states who are afraid that the EU is actually taking over too many policy areas and dealing with too many issues. And decisions are taken very centrally from Brussels. And that's been dictated at the national level and at the local level even, regional and local level. So with the subsidiarity principle, it was hoped that decisions that has to be taken to the closest to the citizen possible. So that's the general principle. So if the objectives of the proposed action could be sufficiently achieved by the member states, and by the reason of its scale or effects, the action could be better achieved by the community, it shall be decided. So there should be a division of powers between the Union and the member states. What does that actually mean? So the division of power between the member states and the division of power between the Union. So if an action can be sufficiently is the important thing that has to be underlined. If the action can be sufficiently achieved at the level that is closest to the citizen, then that's where the action should be taken. So if it's taken at the EU level, better, that's going to be beneficial for the citizens, it should be taken at the Union level. If it's at the member state level, then it should be at the member state level. Or in the case of a regional level, that has to be taken at the regional level, then it has to be taken at the regional level. But let's say it's an issue which is very, very specific to a certain local area, then it has to be taken at that local area. Let's give an example. We're talking about the pollution at the Amir Lake, for example. Let's say that Turkey is part of the EU in this specific example. And there's a pollution issue. Let's say a company is, there's a factory, and that factory is trying to get rid of its wastewater by not filtering it, and the water gets into Amir Lake and kills all the animals that are living in and around Amir Lake. And we want certain action to be taken. So what the EU does say is that it's a very specific issue. It is only related to Turkey, to Ankara, to Ankara's provinces related to the Gölbaşı province. With Amir Lake, it's very, very specific. Why do we have to take a decision at the EU level in Brussels? Then you can actually deal with this issue locally. So you can deal with this issue in your municipality, Gölbaşı municipality, basically. First of all, the citizens in Gölbaşı and Amir would know much better than the people in Brussels, that you will have to go and explain what is going on, what is Emir Lake, what is Ankara, what is this and that, specifically at the Brussels level. It's much better for the people, local people in Ankara, and even like more than Ankara, just the local people in Gölbaşı or in Emir to deal with this issue specifically at the Municipal Council of Gölbaşı and come up with a solution for that. But if you think that this is not going to be able to, this issue is not going to be tackled sufficiently at the local level, then you might be thinking about dealing with it a bit maybe national level, maybe at the EU level. If you think that that issue is specifically related, that there is a gap in the EU legislation that has to be tackled, for example, that there is no regulation, then that can be done at the EU level, that a general, maybe a regulation or a directive or a decision that can be taken at the EU level. But if you can't do it at the local level, do it at the local level. And the reason why they pushed for such some kind of a division of power, first of all, in order to increase the democratic issue in the EU, to involve the citizens more. So to give the message that not everything is decided a bit more hierarchically at the Brussels level, at the EU level. That local citizens should be involved in deciding on their own issues, on their own policies, and they should be part of the decision-making procedures and mechanisms. So at the EU, they're now trying to create this delicate balance. So not everything is centralized, but trying to decentralize the issues as well. Some member states are more keen on those kind of issues because they're not very keen on the centralization of the EU politics in general anyways. And some countries are not super keen on that because they think that this decentralization will create more a less uniform application of certain rules and mechanisms. So there is a kind of a delicate balance in between, but at least the subsidiarity principle is trying to create a more equal distribution of competences between the EU level at the member state level. And all these principles, the general principles of law are valid, as I said, and I'm repeating over and over again, the general principles of a democratic system, a democratic law, rule of law, anyways. So most of the EU member states will have these general principles of law that is valid in their own national system. And this is reflected in the whole EU policies in general, in the EU law in general. And these principles then becomes part of the EU law. Sources of EU law. To put in a nutshell, the whole EU sources in a pyramid. Questions? Comments? Not clear? Very clear?